The next case on our docket this morning, and the final case in our docket this morning, is 2023-3607, State of Florida v. Herard. Apologize if I'm mispronouncing that. Counsel ready to proceed?
Yes, Your Honor.
Counsel? All right, go ahead. Oh, I'm sorry, counsel, you have 5 minutes for rebuttal sufficient?
Yes, Your Honor. 5 minutes would be sufficient. May it please the court. My name is Richard Pals. I represent appellant the state of Florida. The state's seeking reversal of the trial court's order granting the motion to dismiss. The trial court found that the statute was retroactive from the post-July amendments, and it's the state's position that they are not retroactive. This is under 2 points with the state. First is the express legislative intent of section 775-022 mandates prospective, substantive, or procedural criminal laws to be applied prospectively unless one of the 2 retroactive exceptions apply. And it's our position none of those 2 exceptions will apply here. First, if these amendments were meant to be prospective, the text would have said so. It would say the legislator, Your Honor.
But if they meant to be retroactive.
My mistake, Your Honor.
Okay.
That is correct. If this was meant to be retroactive, the actual post-July amendments would say so. They would essentially have said this law is meant to be retroactive. If that is absent, we are now controlled under subsection 3 of section 775-022, unless either subsections 4 or 5 apply. Neither applies here because under 4, this is not a reduction in penalty. This was a newly defined crime. And subsection 5 does not apply because this was not the creation of a new defense. Again, this was establishment of a new element that we had along with that crime. To touch
Counsel, why is it not the establishment of a new defense?
Your Honor, it's not the establishment of a new defense, while I would argue certainly the creation of a new element in arguing that the state cannot meet that element is a theory of defense that someone would advance at trial. It's not referred to as a defense, it is referred to specifically in the statute. It's denoted as an element of the offense. And if they meant to delineate it as a defense, same as subsection 5 of the post amendments, as well as subsection 3 of the pre-July amendments, they refer to what is an actual defense. And that is in cases of carrying a concealed firearm when the governor has mandated mandatory evacuations. That would be the creation of a new defense here. Defenses for purpose of retroactive application are something that's going to excuse criminal conduct or justify criminal conduct, such as in our stand your ground law justifies the use of deadly force or non-deadly force.
That's an affirmative defense.
That is an affirmative defense. That is correct, Your Honor. And then
So
when we get into excusing,
why should we add the adjective affirmative in front of defense when the legislature has said any defense, not just an affirmative defense, but any defense?
well, Your Honor, if that is the case, then we would be rendering subsection 3, I would argue, meaningless. And that is something that we do not.
Subsection 3 of
the 775-022 statute, Your Honor, the same one that gives us the subsections for the exception of whether or not we apply criminal laws retroactively.
why would it render it meaningless?
Because it states that it is presumed, or if the legislator is not going to tell us it is retroactive, we will apply our criminal laws amendments to them prospectively. If we are arguing any time that an element has been changed in a crime, we've added an element or we have tinkered with the elements in terms of enacting a new statute or amending a statute, and we say that is the defense every time, then subsection 3 is not going to kick in at this point.
So in other words, are you basically saying if a defendant gets up in a criminal trial and says, ladies and gentlemen of the jury, they didn't prove their case, that would basically be a defense, and if we follow along with that, then that would be retroactively applied under subparagraph 5 of this statute, and it would render subparagraph 3 meaningless.
Precisely, Your Honor.
So that's what you're, so
That
if
is-
you're saying I'm not guilty, my defense is I didn't do it. My defense is they can't prove it.
The state doesn't have enough evidence. There's a lack of investigation.
As opposed to.
I
I committed the robbery under duress. I committed the carrying concealed weapon under necessity. Somebody was coming in to kill my family, so I found a gun and I defended themselves.
Yes, Your
Or
Honor.
I use self-defense. I was here, they're coming at me. Yes, I killed the person, but I was defending myself because they would have killed me. Those are defenses.
Yes, Your Honor.
Those are instructed to the jury as defenses.
That is correct, Your Honor. Those would be instructed to the jury as defenses. And-
Counsel, if I understand your argument, you're saying that we have to read subsection 5, I guess in peri materia with subsection 3 to make them work together. And if 5 means that every time an element of a crime is amended or added or changed, that automatically adds a new defense, then we'd always be applying these defenses, prospectively.
Yes, Your Honor.
Getting back to Judge White's question, then kind of on what principle do we read any defense to be referring only to affirmative defenses or defenses that sort of excuse a crime as opposed to affecting the elements? I just want to make sure that that we do our diligence and respect the supremacy of text principle that the Supreme Court has validated. Is it simply because we have to read it with subsection 3? Are there any other principles involved here?
Your Honor, other principles, obviously, as the Florida Supreme Court has held in the Connage cases, Ham versus Portfolio, our later cases that we currently have mandating how we control statutory construction. While, of course, in peri materia, I think is very important with this. In peri materia is essentially taken along with conjunction against our canons against surplusage, our canons against meaningless, and our canons that statutes be read also harmoniously with each other. I think those are obviously major ones we have here. Typically at the onset of all this is we're going to apply criminal statutes as well. We're going to stick with what the express definitions are within the text of the statute. We're going to apply
Counsel,
what.
let me stop there. Let's talk about definitions.
Yes, Your Honor.
So defense in Black's law is defined as a defendant's stated reason why the prosecutor has no valid case. Again, Black's law, legal defense. It's or general defense, a denial in broad terms of at least one element of the charge. So
Yes,
under the supremacy of text principles, how can we, instead of construing any defense as those definitions I just said, limiting it to an affirmative defense, which I agree, we've mentioned some of them, justifiable use of force, duress,
Yes, Your
things
Honor.
of that nature. Certainly those would also be included, but why should we limit them just to affirmative defense?
Again, Your Honor,
Given the language chosen by the legislature in making this policy decision.
certainly going into the plain and ordinary language, like you said, utilizing Black's Law Dictionary or utilizing Merriam, what have you. I see how saying a defense is, I would argue the legislator did not choose any theory of defense.
Well, it says any defense to a criminal statute, isn't it?
That's correct, Your Honor.
So just saying I'm not guilty, they haven't proved it. Is that, yeah, I mean, under the Black's Law Dictionary that Judge White's citing, yeah, I guess that's a defense, but it's a defense to a criminal statute here.
Yes, Your Honor. And to be clear, many times defenses are delineated within the statute themselves. They will say it is a defense. And, whether we're dealing with attempt, solicitation and the like, and going into abandonment, which they state later on in the chapter 777. Obviously, in this law, it expressly states when it is a defense, being when you are doing a mandatory evacuation. And even without a license, you will be, or without capability of being licensed because you are ineligible, you would still be allowed to carry the firearm when the governor has mandated the
I mean,
mandatory
a defense
evacuation.
to saying I'm not guilty, I didn't do it. That's. I don't
That
know, is a
anyone can
defense
say
to a
that, Your
criminal
Honor.
statute, that's just a defense is they can't prove I'm guilty.
Your Honor, at this point, I would argue that we would be reading the phrase theory of defense into the language of the statute. And essentially
Would we be
legislative.
would we be reading out to a criminal statute? Any defense to a criminal statute, I suppose, any defense. If it's any defense, yeah, I'm not guilty.
Yes, sure.
They didn't prove it. That's my defense.
To say any defense to a criminal statute and to read it as broadly as proposed here, everything will be retroactive at that point, I would argue. And
Well, counsel, I guess 2 points on that. One.
yes, Your Honor.
If the appellee in this case would already have been found guilty, adjudicated guilty, sentenced, and it's final, even under Section 5, they lose because the legislature has drawn a line, and that's finality, and as well as for the punishment as well, as long as the punishment has not already been imposed.
Your Honor, to clarify, you mean it in under the defense theory, correct? Because I
That
know
is
that,
right.
that technically will still, unlike the reduction in penalty, which goes until imposition of sentence, the creation of a new defense is applied retroactively, even while on appeal, until the judgment and sentence has been affirmed. That still technically will apply. So had the legislator, I think,
once it's affirmed, I mean, when you say it will swallow that, that would swallow subsection 3. It won't swallow it if there is finality. That is, if there's no appeal, it's a final judgment and sentence, or if there is an appeal, it's been affirmed on appeal and it's final.
and for that, Your Honor, there's no prospective application of a statute when there's finality. We don't, after someone's been convicted and their conviction's been affirmed, post-conviction remedies have been exhausted, the state's not seeking further prosecution. The prospective application is for the present prosecutions. That is, along with subsection 3, it states this will not affect the prosecution. This will not affect the charging. Subsection 3 draws out 3 separate subsections under A, B, and C. We are painfully explaining, the legislator, I should say, is painfully explaining that current prosecutions, criminal law, be applied prospectively in all of them, unless, of course, we're meeting the subsection 4 or subsection 5, or this law itself states this will be retroactive. Of course, this law did not state that. When you go to chapter 2023-18, there is nothing within here under any provision that was enacted under that laws of Florida that asked for retroactive application.
Was the basis of the trial court's ruling below actually under subparagraph 4 of 775-822?
That is correct, Your Honor.
Actually said the penalty's been reduced from X number of years to 0 years.
There was no assertion, Your Honor, of subsection 5 in the motion to dismiss below.
Or in the order.
That is correct. Or in the order. The trial court did not make, of course, this court is entitled to de novo review of these things, but without any finding whatsoever on this, courts have held that we would not delve into tipsy coachman doctrine as it is, because this was not teed up by the defendant below. This was not teed up in any.
What factual findings are missing by the trial court in this particular case? I understand there's some cases about not applying tipsy coachman if a factual finding is necessary, which was never made by the trial court. But here, my understanding, correct me if I'm wrong, counsel, is these facts are completely undisputed. It's purely a legal issue.
Your Honor, to a certain degree, yes, this is purely legal, and of course, the state is prepared, was prepared to respond to briefing in this in its reply brief when this was brought up for the first time in the answer brief, and of course, we're prepared here to argue it now. But it's my understanding that the state is here to reverse the trial court's order. The trial court's order was strictly about whether or not this was a reduction in penalty under subsection 4. The state wasn't able to really create any arguments below an order giving the judge perhaps a reason to deny the order.
That wasn't the reason the defendant was arguing.
It was not the reason argued by the defendant. In this particular case, unlike the other 5 that are traveling together with it, the motion to dismiss is slightly tweaked in that it does assert one other option, and that is actually regarding the essential element of the offense, in arguing that because the statute should have been retroactive, the state needed to allege that both the defendant did not have the license and was ineligible for the license. I look at that particular, looking at that, the defendant has essentially conceded in my head that this was an element of the crime and not a defense. Otherwise, they wouldn't have argued this statute's retroactive and the state needs to allege this in the charging information and thus this needs to be dismissed, which would fail on a motion to dismiss anyway, because we cited to the relevant statutory text, which gives the elements of the offense. But at the same time, the defense basically acknowledged that this was an element of the offense and not a new defense when it
counsel,
created its motion to dismiss.
If it's an element of defense, then you're saying, well, that's part of the definition of what this crime is.
That is correct, Your Honor. And I know I
And
was,
so if you look at, as Judge Lambert mentioned, criminal statute in this case, about as broad as the legislature could possibly make it,
yes, Your Honor.
dealing in any way with a crime or its punishment, and then give some examples, defining a crime or a defense to the crime. So distinguishing between a defense, which may be an affirmative defense,
Yes, Your
just
Honor.
to make sure it's covering it, also defining a crime. So if this statute allows the retroactive application of a defense to not defense to a crime, but defense to a criminal statute, which would include an amendment defining or redefining the crime, how does this not fall within the scope of Section 5? And I'll make it a two-parter.
Yes, Your Honor.
If there's some ambiguity, is the statute that the legislature has adopted in 775.021 sub 1, the rule of lenity, require that we construe that in the most favorable to the defendant?
Your Honor, to respond to your two-part question, first with the first question that you proposed, talking about defining a crime or a defense, that present participle phrase, defining a crime or a defense, that goes into the state's assertion that, again, when we are going through whether or not a statute's plain language says something or whether it is plain and unambiguous or it is ambiguous, we also apply, the traditional canons of construction, and that applies the negative implication canon. I know I already went through surplusage, meaningless, harmonious readings. That's the last canon that I did not employ yet. And by going into negative implication canon, as I pointed out in the briefs, defining a crime or defining an offense or defense, that is two separate members of that definition of what a criminal statute is. We've already said criminal statutes apply prospectively unless two of the exceptions under subsection 4, subsection 5 apply. Subsection 4 is the punishment. In reduction in the punishment, criminal statute says it establishes what punishment will be. It states that it will define a crime. It states that it will define a defense. Negative implication canon shows that it would say the establishment of a crime or the changing of a criminal elements, the amending of a crime, redefining a crime, however have you. By reading in that express definition of criminal statutes, the state did put this out in its brief, by talking about defenses, talking about sentences, but not talking about defining the crime itself. And this here is defining the crime. It is stating what criminal conduct is now. Based on the post-July amendments, citizens are authorized to carry as long as they are eligible for licensure. The crime is to not be eligible for licensure now, carrying a firearm when non-citizen, under 21, or as a felon. So it's the state's position, Your Honor, that going under subsection 2 plays into the state's assertion that the express legislative intent of subsection 3 is not defeated on these post-July amendments by subsection 5, the establishment of a defense.
You ran out of time.
I see that I am eating into my rebuttal time here, Your Honors. I'll reserve the rest of my time for rebuttal unless this court has any other questions at the moment.
All right, thank you.
Thank you, Your Honors.
Counsel.
Yes, Your Honor. May it please the court. My name is Joshua Sinclair and I represent the appellee, Naya Herard. Trial court order should be affirmed because the changes and amendments to the carrying concealed statute, Florida statute 790.01, apply retroactively under Florida statute 775.022 under subsection.
Was the basis of the trial court's order, the subparagraph 4 of 775.022, that it was the reenactment of the statute reduced the penalty?
Yes, Your
Is
Honor.
that the sole basis for the ruling?
Your Honor,
Basically?
I would say that was not the sole basis. This was filed as a C4 motion. The facts were not disputed. The trial court did only discuss 775.0224. However, the trial court specifically stated that the appellee did not commit an offense under the new statute. And I
Well, she
believe
did.
that,
Right, and I mean, if she would have done this July 10 of 2023, then she wouldn't have committed a crime.
that's correct, Your
Okay,
Honor.
but the problem is she didn't do it before. She did it before that.
Right, yes, Your Honor. And although the trial court did not specifically refer to subsection 5, trial court's finding that she did not commit a crime, that language can be used to show that she's putting forth the defense that she would not have been ineligible to have a permit.
Well, I'm looking at the order. I mean, it goes on. I mean, every page of the order, it looks like, talks about subsection 4. And it talks about the Dean case from the 5th DCA, which isn't that a fairly distinguishable case from the present?
No, Your Honor, I wouldn't. It's distinguishable in the sense that the Dean case,
Watch, I wasn't on that panel, wasn't I, before I started saying anything about it? Go ahead.
the Dean case is distinguishable in the sense that it dealt with stripping the court of jurisdiction because it went from a felony to a misdemeanor.
Well, because the penalty change, I mean, because the elements changed. I mean, it went from $400, what was alleged in that case was stolen, was no longer a felony.
That's correct.
And
Your
so the penalty changed. I mean, the elements of the crime didn't change, the penalty changed. And so in Dean, we basically said, you no longer have jurisdiction circuit court because the statute subparagraph 4 of 775.022 comes into play and it makes it a county court case, right?
Yes, Your Honor, although I would disagree that the elements didn't change. The element for grand theft changed from $300 to $750. So there was a change in elements within the theft statute. And that's very similar to what we have here in that the elements have changed for what constitutes criminal carrying of a concealed firearm. And in that manner, that these cases are not distinguishable.
All right.
Counsel, it's supposed that we wanted to focus on subsection 5. As I read this statute, it says this section may not be construed to limit the retroactive effect of any defense to a criminal statute enacted or amended by the legislature. Doesn't subsection 5 deal only with defenses that are enacted by the legislature or amended by the legislature as a matter of statute, as opposed to you didn't establish an element of the offense, which is not a statutory defense. It's just sort of a theory of defense.
No, Your Honor, I do not believe that's the case. It specifically says limit the retroactive defense of any defense to a criminal statute. Had the legislature meant affirmative defenses, they would have put affirmative defenses, but any defense would be negation of an element is a defense to any criminal statute.
But the statute doesn't stop at any defense to a criminal statute. It says any defense to a criminal statute enacted or amended by the legislature. Doesn't there have to be an enactment or an amendment of a defense in order for subsection 5 to apply?
No, Your Honor, the way I read it is it's any defense to a criminal statute enacted or amended by the legislature. So read it as two separate parts. You can't limit the retroactive effect of any defense. The second part is to a criminal statute enacted or amended by the legislature.
Does that make the most sense though? Because a criminal statute is necessarily something done by the legislature. To add the modifier enacted or amended by the legislature, it only makes sense to me if it's talking about a defense. A statute is necessarily a creation of the legislature.
Yes, Your Honor, this subsection 5 needs to explain the mandate that this entire section or the 775.022 not be construed to limit the retroactive offense. That's a mandate from the legislature. The fact that they wrote enacted or amended by the legislature in a criminal case I don't believe there's surplus in there because they're talking about a statute when it's enacted or amended rather than repealed. So if the statute was repealed, I think we'd be in a different situation. And so they're narrowing it to just enacted or amended rather than repealed or anything else that legislation may
Well,
do.
let me ask them. I mean, I'm trying to think of the hypothetical. If you saw the last thing, we have a lot of hypotheticals, please come out of my mouth. All right, so if I'm looking at the statute, it's subsection 3 of 775022. If the statute stopped there, no force, no subparagraph 4, no subparagraph 5, you would lose.
That's correct.
Okay.
Yes.
All right. Then for the purpose of this discussion, let's assume you're not going to win on your discussion on subparagraph 4.
Yes.
Okay, so now the focus is on number 5. And so what I'm trying to gather here is the position that you're saying is a defense is defense. I'm not guilty. You didn't prove it. So give me a scenario where it seems to me that's completely surplusage because you're always going to have as a defense, I didn't do it, or I didn't do it. I'm not guilty. Now my defense is I'm not guilty. My defense is the state didn't prove their case. I don't put on any evidence. I get up and said, well, ladies and gentlemen, jury, they had to prove all 3 elements. They didn't prove number 3. They didn't prove their case. Have a nice day. Please find me not guilty. So that's a defense. Under your scenario, because it's a defense, it applies retroactively because the statute of which your client is charged was amended. That would seem to apply to every time the criminal statute is amended. Or give me an example where it wouldn't. Maybe that'll help me work this in my head.
So an example would be if the elements are not changed at all and just the penalty. If we,
Okay, well then we would be at number 4.
right,
Right,
but I'm
okay.
saying in that case, number 5 would not apply.
Right, no, I agree, yeah, if you had number 4, if the statute we're talking about today, if the legislature said, and if you commit this crime, it's now a 2nd-degree misdemeanor as opposed to a 3rd-degree felony as of July 1, 2020, then you'd say Dean, look at Dean. So misdemeanor, I mean, or you'd say I'm not guilty at all, but let's say they didn't change the elements, but yeah.
Another situation, Your Honor, would be if the legislature added removed an element, then it wouldn't apply retrospectively. It would only apply prospectively. And there are ex post facto issues there too, but the legislature is aware of that. And in drafting this, they clearly didn't want to violate ex post facto laws. I think another example would be with possession when back when the legislature amended it to change possession from lack of knowledge of the illicit substance from an element to an affirmative defense. I think in this situation, because of the ex post facto principles, this statute, I guess, would apply, but ex post facto would knock it out. But the way the statute is written is it's to give the defendants as much benefit, retroactive application, if they haven't been sentenced and their case isn't finalized, but they don't want to run afoul of the ex post facto laws, because without subsection 3, ex post facto would be violated, would be violated if all criminal statutes applied prospectively.
Okay. Well, I agree with you, but go ahead.
Counsel, can you, when we're talking about affirmative defenses like justifiable use of force or insanity or entrapment, whatever the case may be, can you think of any examples where a defense, meaning something that avoids a crime, not just negating an element, but actual affirmative defense is not provided by statute? Or to flip that around, is there an example of a statutory defense that would not also be an affirmative defense?
Self-defense.
Yes, self-defense, Your Honor. Cannot think of any other ones. And just so I understand your question, is Your Honor asking an affirmative defense that is not provided by statute, or any defense defined by statute is automatically an affirmative defense?
I'm asking, is there any, can you think of an example of a statutory defense that is not also an affirmative defense?
Self-defense, Your Honor. I cannot think of any other statutory defenses, other than the argument that when the burden of proof is placed on the state, negation of that element is a defense, and arguably that is a statutory creation of defense.
When I look at the prior version of the concealed carry statute, there's a Florida Supreme Court case from 2013, Mackey v. State. And there, when it used to be subsection 3, it said, it's not a crime to carry the concealed weapon if you've got a license. And the Florida Supreme Court said that is an affirmative defense. So, before the statute changed, having a license was an affirmative defense, according to the Florida Supreme Court. Now, having a license is up in the elements. Doesn't that sort of statutory change, based on how the Supreme Court used to interpret it, tell us that, it's no longer a defense to say I have a license. It is now, part of the crime. It took the, something that used to be in the nature of a defense and made it no longer in the nature of a defense. In other words, now the Florida Supreme Court wouldn't say that it's an affirmative defense. And I don't know how we could say that it's any kind of defense at all when it's specifically identified as an element of the crime. Am I missing something there with that statutory change?
Your Honor, by adding an element, the legislature has necessarily created a defense. So if having a license means you can't be found guilty of the crime, that is an absolute defense that you can raise, that the state has not proved. That the same thing with whether you would otherwise be ineligible. So the creation of an element necessarily adds a defense to any crime.
So you're basically saying if you add an element to the crime, you've added a defense because your defense is you haven't proved the new element of the crime.
Yes, Your Honor, that's correct.
Somewhat circuitous, right?
I don't believe.
And therefore it's retroactive.
Yes, when
And that's your argument. I mean, I know that wasn't discussed below basically, but that's the argument that is going to be the carrying the day one way or another, because I don't think you're going to win on number 4. It's up here at 4.
Yes, Your Honor.
But
And it is, yes, I mean, as
because we create an element and we statutorily says this is an element you have to prove to the state. Your position is that because you create an element by the amendment, you have created a defense, and my defense is you haven't proved the element, and therefore it is retroactively applied, even though it is a new element that the state has the burden of proving. That seems to be what you're saying to us in justifying an affirmance, probably for reasons unrelated why the trial court ruled.
yes, Your Honor, that is correct.
Fair enough.
Counsel, do you think that as part of our statutory interpretation, we have to consider the context of the amendment?
Yes, Your Honor.
And so in terms of the context, I mean, this statute 775.022 was enacted by the legislature in response to the amendment to the Constitution, correct?
That's correct.
And previously, the legislature was prohibited in retroactively applying either an amendment or reenactment or enactment by the Constitution.
That's correct.
Now that has been amended, so the legislature is only prohibited in retroactively applying a repeat. Exactly.
That's correct.
And so now the legislature has the ability, although not the obligation. You agree, this is not, the case law indicates that the legislature may decide to provide retroactive relief to criminal defendants, but they're not required to.
I agree.
And so they've chosen to do that under the terms of 775.022.
I would agree with that.
And so I guess your argument is, one, the statute by its plain language would allow a more favorable amendment to from the defendant's perspective with respect to punishment, provided the defendant has not already been sentenced.
That's correct.
So there's a limit to sort of the legislative grace.
Yes,
That
sir.
is, we're not going to undo things that have been final.
That's correct.
And seems even the state agrees that if it's affirmative defense, the legislature has exercised that same grace. And that affirmative defense could be a defense where the defendant has a burden of production. And if he meets the burden of production, it shifts to the state to prove beyond a reasonable doubt. Defenses like that, correct?
Correct.
Or the legislature could create an affirmative defense with an actual burden of proof on the defense.
Correct.
But again, provided the judgment and sentence wasn't final, that could apply retroactive.
Yes, that's correct.
Well, they could have contextually just said, okay, we've seen the constitutional amendment. Except for everybody who's already been sentenced, because we're not gonna do, 50 years of penalties. We're just gonna say everything's retroactive from the get-go, because that's the will of the people now. But they chose not to do that in the context of amending the statute shortly after the Constitution was amended.
Correct. It seems like their concern was running afoul of the ex post facto clause. Had they done that, then this statute would be unconstitutional because it would run afoul of ex post facto. Are there any other questions?
No further question.
No.
All right, thank you very much.
Thank you, Your Honor.
Counsel, so to sort of follow up to my questions to opposing counsel before you came up. Would you agree that if it's a favorable amendment in terms of punishment or a favorable amendment in terms of an affirmative defense, then those would apply retroactively?
Your Honor, that is yes, in the text of both subsections 4 and 5.
But if it's a change in a statutory element, which actually is more favorable to the defendant because it puts the burden on the state from the get-go to prove that a crime was actually committed, that doesn't apply retroactively.
That is correct. That does not apply retroactively, Your
So
Honor.
if this eligibility of a license was created as an affirmative defense in the statute, it would apply retroactively, but because the legislature has made it more onerous for the state to go against the citizen, that doesn't apply retroactively.
Yes,
That's the way we have to read the statute.
well, yes, Your Honor. I mean, because they have redefined the elements, it does not apply retroactively. I understand it's the same application as how you pose it, Your Honor, but it does not apply retroactively because this had to do with defining the crime or redefining the crime.
So it's the form of the amendment that controls. If they put it as an affirmative defense and call it an affirmative defense, it's retroactively, but if they put it where the burden never leaves the state at all, but it's a brand new element, doesn't apply.
That is correct, Your Honor. I believe you are speaking about abatement at that point. We're saying that we've made this more favorable to the defense, and that is decried under the first subsection of 775-022. We essentially supersede any common law concept of abatement here.
Sure.
When we decriminalize something. And here it is decriminalized. The original law states that if you carry without a license, you have committed a third-degree felony. Here we state you are authorized to carry without a license if you are eligible. It is a violation if you carry without that particular license at this point. So here we have, again, as I stated before, we're dealing with defining the crime and we're not dealing with a new defense. And again, on top of abatement, the statutory express intent that we have within here, I know that I am eating in my time. So of course, Your Honor, if you'd like me to wrap up, please let me know.
With our questions, I'll give you a little bit of time just to wrap up.
No, it's appreciated. I think, Your Honor was questioning the defense about the concept of it saying amended by or enacted by the statute. And I think that that plays into how we know that a defense has to be created by the statute in order to say that we are going to apply a defense retroactively under subsection 5 based on the text they have there, and how we don't run afoul of the defining crime definition of criminal statutes under subsection 2, the express legislative intent of subsections 3, as well as abatement under subsection 1. And on top, I believe I don't need to address Dean. This court seems to have a very strong concept of how that is inapplicable here. But here with this stating any defense is anytime I say I didn't do it or they didn't meet an element, I believe that's eating into the statutory language here, and that fails in the face of the negative implication canon as stated in the state's brief. If this court doesn't have any other questions, I will rely on my briefs, and I ask that you reverse this case as well as the 5 cases traveling together with it.
All right, thank you.
Thank you, Your Honor.
Thanks to both counsels. Well argued. All right, we will be in recess. Thank you.